I mean, your bio is so long. I mean, it's like 18 miles long. I mean, don't you?
I'm old.
We didn't ask last night, but how did you get to Hogan and Hartson?
Well, I had just been clerking for 3 justices, and so I pretty much had my choice. And I liked everything about the firm. Not only the quality of the lawyers, but something about the atmosphere. There didn't seem to be fighting as much as I heard stories about in other firms. And there was a generous and genial atmosphere there that appealed to me.
Were they all at all concerned that you were the son of a federal judge? That once they hired you, they probably didn't know how to deal with you?
I heard later that when my name came up to be hired by the firm, Nelson Hartson said no dice. And they said, Nelson, for heaven's sakes, the guy clerked for 3 justices. Yeah, but this old man's a judge. If he doesn't work out, we'll never get rid of him. That's the only thing I was aware of. And they voted me in despite that.
Well, almost 60 years, they haven't figured out how to do that, have they?
No, that's right. He was absolutely right. Absolutely right. Could never get rid of me. What are we doing here? What?
It's you and I, friend. These are just
ex-friend.
How did it go last night? You know, here we had this great opportunity for you to sit down. I did a little talking, and basically it was you and the Chief Justice talking about your career. What was your reaction when you went home last night?
When I got home, I was ecstatic because the response from the crowd was really more than I had hoped for. When I was doing it, I wasn't ecstatic at all. Because I just didn't know instinctively how it was going until it was over. I had prepared for that sort of like a Supreme Court argument. I had a whole notebook full of possible responses. I was going to cite things such as when he was arguing where a fellow in prison was claiming that he was being subjected to cruel and unusual punishment because he was in a cell with a smoker. And John was in the Solicitor General's office and was arguing that that was not a violation of the Constitution. And Justice White said, well, what about suppose asbestos was there? And John right away said, well, now that might well be cruel and unusual punishment. If you go to a dining room, they'll ask you, do you want the smoking section or the non-smoking section? But they don't ask you, do you want the asbestos section or the non-asbestos section? And that was the kind of thing that I had prepared to use. And I didn't have to use it. The only thing I used was the excerpt where John was correcting Justice Kennedy, who had thought that if you just X'd out one little part of an opinion or of a statute, you could change the whole thing. And John quite properly said, well, no, if you X out here this, you've got to X out that, and then you've got to X out this, and you've got to X out that. And why not at the very end X out the whole opinion and just reverse it? That's the only thing I used.
Yeah. What other little goodies did you have? Do you remember?
No, I've submerged them all.
The moot court process of preparing.
Oh, yeah. Well, I wanted to make sure he had used moot courts, and he told me that he had quite a bit. The moot court that we used when he was with us, and he was with us for 13 years and 9 months, the ideal one was 3 judges, and they would be 3 lawyers in the office, one of whom would be very familiar with the case, one of whom would not know anything about the case, and then a third one. And what you would duplicate there is a judge who comes to the case and doesn't really know much about it, hasn't done his homework, and the kind of questions that he would ask, or she, and then, of course, the kind of questions that someone who was completely and thoroughly familiar with the case would ask, and then a third who knows what would be asked. And we would time it first so that the speaker, the advocate, would get only the amount of time that he or she would get at the oral argument itself. And when we did that several times, we would then just go indefinitely till questions ran out, no matter how long it took. And at each stage, we would discuss, criticize, answer to questions, suggest answers that weren't given, and do things of that sort in order to prepare the advocate as closely as possible to what might actually occur at the argument.
You brought back his partner. Did he soon become the sort of the head of the appellate division? Did he have a different strategy than you when you were the head of it?
Well, he definitely was. We didn't have names for the head of it and so forth, but it was understood that he was the top guy. White and Stevens were difficult for different reasons. Stevens, because he would always detect if I had a problem in the case. And right at the end, when I was about to sit down and in fact would get halfway back to my seat, he would say, "Oh, by the way, Mr. Prettyman," and put his finger on exactly what my problem was. So he was very kind about it, but very astute. Justice White, as I indicated, was tough, and he would normally not let you go once he was on to you, and would disagree and would not let you go. I think they were the toughest I had to deal with.
Your oral arguments are available online. Have you ever listened to your oral arguments?
No. I didn't even listen to find out what answer I gave to Justice White to the question that I never heard. I'd like to go back sometime and see what that was.